Okay, hello everybody. My name is Jay Huang. I am an associate at Scott Legal PC. Today, we are going to spend some time talking about a topic of high interest from E-2 visa clients, which is what are some of the pathways E-2 visa holders can explore to get a green card, permanent residency in the United States. As many of you may know, Scott Legal was founded on an E-2 visa, and we specialize in immigration options for entrepreneurs and investors. A few things before we get started. Scott Legal is a full-service immigration law firm. Our main specialty is E-2 visas, and we regularly process a high number of them. But we do assist individuals pursuing various types of visas, including family-based, employment-based, and we help entrepreneurs pursue green card applications in various categories. We will be continuing these webinar series, doing at least 2 webinars a month on different topics. At the end of this webinar, we will be sending out a few things. First, we will be sending you a PowerPoint that has all the information that will be covered in this webinar. We will also be sending you a comprehensive guide covering the visa categories that we will discuss in this webinar today that you can use as a reference. We will also be sending you a link where you can sign up for additional webinars in the future, and also this webinar as it will be recorded. Finally, this webinar will be available on YouTube, and we encourage you to subscribe to our channel as we regularly upload immigration-related videos. Finally, we will also be sending you a link where you could follow to schedule a consultation with us if you wish to discuss your case further. So today, we are very lucky to have Ian Scott, president and the founder of the firm, with a wealth of E-2 visa experience, who is an entrepreneur himself, currently on an E-2 visa, and he is helping a variety of entrepreneurs and investors to pursue green cards, who will be answering these commonly found questions regarding possible green card pathways for those on an E-2 visa. Finally, for any questions you may have, you can add them to the chat box or the Q&A box, and we will try and get to all questions. So without further delay, let us move into our questions. Okay, so just as a quick introduction and to bring everyone up to speed to E-2s, Ian, what is an E-2 visa?
Thank you very much, GA, and it's great to be here. And as you mentioned, E-2 visas are near and dear to my heart because I'm on an E-2. The firm was founded on an E-2. But also, we take have a great amount of pleasure with respect to assisting many clients moving from E-2 to green cards. So an E-2. It's a great visa for entrepreneurs, people who either want to start a business or want to purchase a business. And it's a visa that just requires that you invest money into the business. So you're going to be investing the amount of money that's required to get that particular business up and running, or if you're purchasing a business, to the amount of money required to purchase the business. And you are going to, the other kind of big thing with an E-2 visa is that you will be able to, the business has to be able to support US workers, so employees. Employees are a big thing with E-2 visas, so you have to be able to support employees. Now, the other really significant thing with an E-2 visa is the E-2 visa is not available to everyone, because the E-2 visa is only available to nationals of certain countries, and there are about 80 or so countries on the list. But very broadly speaking, if you are looking to start a business in the U.S., purchase a business in the U.S., and want to do that and develop directly operations and live in the U.S., then an E-2 visa certainly could be a good choice for you. And this particular visa. We have people that invest as low as $40,000. Some invest a lot more. But it's not a visa that requires if you to refinance your home necessarily to start the process.
Right, so a relatively accessible and versatile visa for entrepreneurs for sure. So Ian, then why would people on an E-2 visa, why would they want to move from an E-2 to a green card?
Yeah, it's a great, and I think that it depends on the individual's personal circumstance and kind of what security they want. So the E-2 visa is a visa that can be renewed indefinitely. So I've been on the E-2 visa for over 10 years, and I'm comfortable on the E-2 visa. I'm not really looking to move to a green card. I sometimes, kind of go in and out in terms of living in the United States, not living in Europe. So, and I'm still Canadian. And so for me, the E-2 visa is perfect. It gives me a lot of flexibility, But there are individuals who want more security, more permanence. They want a green card because they want to be able to send their kid to schools, and there may be certain scholarships that are only available for people with green cards. They may want to become citizens, because if you're a green card holder or any other type of visa holder, you could be deported. Citizens can't be deported from the United States. So it gives you, more security. So sometimes people do want that security, especially if they know that the US, they want the US to be their home. Other kind of benefits is that the green card will lead you on a path to being able to vote. That's, very important to a lot of people. Because the steps are always going to be green card, then citizenship, right? So there are few exceptions, but generally speaking, the path to citizenship is going to be green card first. And that's why sometimes a lot of our clients on E2 are looking for a green card option. Some of our clients on E2s have been here for over 20 years, been in the US for over 20 years. So it's, they're looking for a little bit more permanence, because as we all know, laws can change, right? So if you become a citizen or a green card holder, there's not much that could change there, right? In the sense of you already have the permanent residency card, but that's what a green card is, a permanent residency card. But during past administrations in particular, certain non-immigrant visa types really did come under significant attack. E2 fortunately wasn't one of them, but who knows in the future that and laws could change, making the keeping that particular visa or being able to stay in the United States on that particular visa would make it more difficult, and that certainly wouldn't exist if you had a green card or were actually a citizen.
Right. So definitely the degree of stability that a person may need in terms of their long-term plans, that would play an important role. Right. So, Ian, would you be able to describe then, how does the green card system work in the US in general? And in particular, does the US have a point-based system like in other countries for obtaining green cards?
Yeah, it's a great question, and I think that to answer the last part of the question, unfortunately, the U.S. doesn't have a points-based system. So there are certain countries like Canada, that, for example, and other countries that have a points-based system that really looks at a number of different things. It might look at how long you've been in the country, do you speak the language, your age, your financial position, a lot of different, are you a skilled worker, different things like that. So each country might develop what they consider most desirable for that particular points-based system. There might be other ways to become a permanent resident of a particular place, but the points-based system is good in the sense of it often addresses the kind of situations where someone's in the United States in a particular country for a long time. Let's say someone goes to Canada, they're educated in Canada, they're a highly skilled worker, they've worked there for many years. They're fluent in one of the two official languages. It gives them the ability to obtain some type of permanent residency. Whereas unfortunately, when you're looking at the way the system in the US works, there are just a list of green card categories. And with this list of green card categories, you are going to either be able to apply for one of the categories or not. So, you could be in the United States, I've been in the United States for over 20 years, and there's no kind of immediate benefit, or there's no category that says, well, one of the factors we're going to look at is that you've been in the United States for a long time, or that you went to law school in the United States, or you pay taxes here for 20, none of that. Well, US will have none of that. They're just a list of categories. Now, they're broken out into, for the purposes of this discussion, because there are a few more categories, but the two major categories are family-based and employment-based. And then within the family-based, those are further broken down. And then within the employment-based, those are further broken down. So, for example, there could be an opportunity for someone to obtain a green card through their company sponsoring them, right? Like it's a very generally speaking, that, you know, you get a job offer from a company and the company says, well, we want to sponsor you for a green card. That's so now when we look at that particular category will have a bunch of requirements to be able to get the green card. And that's how they all work. Like even under the family-based category, you know, it's not as simple as I have a relative in the United States. We say it was a relative in the United States, then you have to say whether it's eligible, whether the green card category is current, how long are you going to have to wait, and things like that. So yeah, so it isn't, you know, when we have someone in the United States on an E-2 visa, there's no, you know, there's no, as I said, you know, the examples that I used before, that there's some people that are in the United States for over 20 years, have paid taxes for over 20 years, you know, significant contribution, many employees, but unless they can qualify for one of those other green card types, they wouldn't unfortunately be eligible for a green card.
Right. From that, I imagine I've also heard this before I became an immigration lawyer, that if you stay in the US for a certain number of years, then you will get a green card. But that is one of the most common misconceptions. And it really seems like there are these quite strict categories, and you need to meet all the requirements for each category in order to be eligible for a green card. So there is no automatic pathway to the green card.
Exactly. That's exactly right. Yeah.
So maybe let's then break down some of these categories for the audience here. So what would be some of the common types of family-based green card options
Sure.
to start there? Do you see when people are moving from an E-2 to a green card?
Sure. So one, you know, very common, and within the family-based green cards, they're broken down into two subcategories. So one category is called immediate relatives, but immediate relatives are not what we would necessarily think of an immediate relative, like a sibling, for example. We'd think of that as an immediate relative. The immediate relative is defined by law. So an immediate relative would be a US citizen marrying someone, or it would be a US citizen that was 21 that was sponsoring their parents, right? That's immediate relative category. But then the next category is, they're called preference-based categories. And I'm not going to go over all of them, but there are a number of them. So for example, US citizen sibling sponsoring another sibling, right? So that's one of them. And there are many of them. So you know, you'd have to go to the particular preference-based category. Now with E-2, people moving from E-2 though, what we tend to see is that they will utilize the immediate relative category for this reason. So that would be someone here on an E-2 and they marry a US citizen, right? That's, you know, one way. And the reason that is much more prevalent than some of the preference-based categories is that the preference-based categories are, most of them, almost all of them, are what's called, it's an immigration term called retrogress, but that just means they're delayed, they're not current. So for example, if a US citizen sibling, so let's say someone was here on an E-2 and they had a brother or a sister that was in the US and they were a citizen, and they said, oh, well, great, I'm here on an E-2, can you sponsor me for a green card? They most certainly can. However, it would take around 15 years before the green card category to become current, and there's no benefit that's afforded to the E-2 visa holder during that time. So it makes it fairly impractical to be sponsored under that category. And that's one of the longer categories, but most of them are long waits, over 5 years or, you know, 10 years in some cases. So most of the preference-based categories are quite delayed. So we don't see a lot of people moving from E-2 to a family-based green card, but instead we see it more under the immediate relative and under the immediate relative category.
Right. And I think it'll be important to note that just by filing the petition itself doesn't automatically extend somebody's status.
Exactly.
If they're in the US.
Exactly.
Right. And so in terms of the procedural aspects of getting a green card, there are two ways to do this. There is the consular processing option and there is the adjustment of status option. And now, could you briefly explain what are the differences of these two options?
Yeah. So an individual who's in the United States has a choice of either taking a consular processing route or an adjustment of status route. So we'll deal with that person first, because, you know, presumably the person that is on an E-2 is going to be in the United States working on their business. So now if the person is on an E-2 visa, then they can do what's called adjusting status. Now, adjusting status means that you're filing paperwork in the United States. So now we kind of first like we're always thinking of this in kind of looking at it in kind of two dimensions. So the first dimension is that we're first filing paperwork that looks at the objective aspects of, is the person eligible for the particular category that they're applying for. So some of the different types of green card categories, we're going to talk about them today, but we talked about one already. So let's say that the person was marrying a US citizen, the E-2 visa holder was marrying a US citizen. So the first part of the process is always going to be, is the person eligible? Like, is it a bona fide marriage? Is the person actually a US citizen that they're married to? And just the objective facts. And there's going to be a petition that's filed for that. So and every single group may have a different petition, but for all of the family base, because that's the one we've talked about so far, we would file what's called an I-130 petition. And as GA mentioned, that when you just file the I-130 petition, it doesn't afford you any benefit in the United States whatsoever. You've just filed the petition and you're waiting. So now, though, if someone is in the United States and they want to adjust status, two things have to have happened. So the first thing has to be that the visa category has to be current, right? So I just talked about some of those categories that are retrogressed or delayed. So if you're marrying a US relative, the visa category is always going to be current. But let's say that it was a sibling sponsoring you, you actually wouldn't be able to adjust status. But let's say that an E-2 visa holder was marrying a US citizen, and then they said, okay, well, I'm going to adjust status. And because they're adjusting status, they're filing this petition. It's called an I-485 petition. Then once that petition has been filed, then the individual is in what's called a period of authorized stay until the I-485 petition has been adjudicated. So they can stay in the United States, even for some petitions that might take years to adjudicate. And there are some, they're allowed to stay in the United States all of that time pending the adjudication of the I-485 petition. Now, the other benefit of the filing the I-485 petition is that the person has the ability to apply for work authorization and travel authorization. So depending on, like, an E-2 visa holder may not need this because they may still have the underlying basis of the E-2 to continue working, but in some cases it can be beneficial. So that's what the adjustment of status process is. Now, with the adjustment of status process, the one thing you have to be careful of is that when you file the adjustment of status application, and if you're on an E-2, you can't leave the US until that travel authorization has been approved, right? Because if you do, that means you've abandoned the I-485 application, and then you would just have to consular process or something like that. But that sometimes can take a long time. It can take 6 months, 8 months, a year. It can take a long time sometimes to get the travel authorization approved. So it is possible that if you do the I-485 application, that you might be landlocked. Now, so that brings us to then, well, what's my other option? And the individual can do something called consular processing. So when you do consular processing, that means if the person's in the United States, so if they're on an E-2 in the United States, they're, chugging away, working at their business, they have valid E-2 status and continue to have valid E-2 status. And then instead of doing an adjustment of status process, they say, well, I'm actually going to get the green card at the consulate. So they initiate a process at the consulate. And sometimes that can be beneficial, especially if, for example, you can't stay in the United States for the 8 months to a year to get the travel authorization, or if you have underlying status and you don't really need the benefits that the I-485 petition afford you. And then there are always a few things to consider, because the filing at the consulate might be a little cheaper, depending on the timing. It could be faster, could be slower, like depending on which consulate you're going to. So there are a number of different considerations that we're going to look at. We're going to look at. We're also going to look at how fast will the underlying petition be adjudicated, because in this case, the example that we were using, if we're saying that the person's applying for an I-130, there's not really any ability to expedite that I-130, right? There's some petitions that we're going to talk about where you can pay the government a fee and have an answer on the objective part of the petition, have an answer in a few weeks. But for some petitions, you won't have that answer. So there's a lot that kind of goes into the decision of should we do consular processing? Should we do adjustment of status? And we're often working with clients to see what their actual goals are, to assess what would be better for them in terms of filing.
Right. And one thing that I also note is for consular processing, you would really start the process once your underlying immigration application is approved. Whereas for adjustment of status, you used to be able to file concurrently for many categories. And for other categories, you could file anytime after the receipt notice has been issued.
Exactly. Yeah, exactly. So yeah, and exactly, because it's almost like you'll go category, look at each category, assess where are they in the process, like have they do they have the objective part approved? Is it eligible for premium processing? Is it are there significant delays? But then also the other kind of layer is just what's going on in both USCIS, because USCIS, the government in the United States, they're going to be the ones doing all of the 485 applications, whereas we can have some idea with respect to how long that's going to take versus a consulate. We also can have some idea how long that's going to take. And then, of course, you're adding in the added complexities of COVID and timing at consulates and things.
Right. So it can be quite an important decision, requiring a lot of strategic thinking.
Exactly.
Right. So a related question now here is, can someone keep working while their green card application is pending? And I think you may have touched on it.
Yeah. And I think it's a great, it's a great question in terms of it, with all of these visa options and green card options, planning is absolutely key, because the answer is it depends. It depends on what is going on in their particular situation. It could be that they filed for I-485 and they have work authorization and that was approved, and that's giving them the underlying basis for approval. It could be that they have some other underlying basis, like the E-2, for example. It could be that they have the underlying basis for that, so that's giving them work approval. But I think the key takeaway point is that filing an immigration petition doesn't necessarily afford you the ability to A, continue working, or B, even stay in the United States. That's something you have to understand. And that subtlety sometimes does get lost, despite the fact that we're constantly saying it to clients, that subtlety unfortunately sometimes gets lost. Sometimes clients think that just because the law firm is preparing their application, that it gives them the ability to stay in the U.S.
Right.
I haven't quite understood that, but that's sometimes what happens before anything's filed. And but even when something's filed, it really depends on what is filed. And what your underlying basis is. And then sometimes it even changes, because if, for example, you had an underlying, like let's say you were here on an E-2, and then you had your travel authorization approved, but not your work authorization. And then you left the United States, and then you re-entered the United States. So now you've re-entered on parole, not on E-2, right? So you re-entered on parole and you don't have work authorization, because you can't just start working again on your E-2, because you're no longer in E-2 status. So you now have to wait until the employment authorization has actually been approved, because they can be approved at different times, the travel and employment authorization. So I think it's a great question in terms of you really have to plan and understand what is going on, like what's the underlying basis of your ability to stay in the United States and your ability to work in the United States. Because it's almost like every visa can be compartmentalized and kind of a bundle of rights associated with that particular visa or petition that's filed. And then it just depends on what has happened that will determine whether or not you are able to work or are able even to stay in the country.
Right. So a lot of subtleties are there. And another reason why you want to consult with your immigration lawyer before leaving the United States, if that is the case.
Exactly. Yes, it's a great point, because there are certain instances where people, petitions filed and, the person just takes off, doesn't say anything to anybody, not to us, not to their immigration lawyers. If it's not us, doesn't say anything, just takes off. And then, And yeah, and then there's, they're not aware or not, surprised that, that their petition's been abandoned, right?
Right.
But it's because it's, and sometimes I understand it is sometimes hard because lawyers will send documents that are bold and highlighted that say don't do this, right? But I understand people, there's a lot going on. So but it's definitely, you can never communicate enough with your legal team to make sure that you're not doing something that's going to lengthen the process. And and it's not the end of the world. It just might mean that you have some time out of the US, or that you have to consular process or something like that. So
Right, definitely. Okay, so now we can maybe switch gears a little bit. And yeah, earlier you also mentioned that there were employment-based green card options. So Ian, then which green card category, in your opinion, is the most popular when someone wants to move from an E-2 visa to a green card?
yeah, I'd say, it's a toss up, but I think I'm going to pick, the EB2 national interest waiver. Now, this one I like a lot because it's a very creative green card petition that really I think there has a lot of potential, a lot of possibilities, and we're doing a number of them. I think we just had one approved just last week for an entrepreneur. And so what this particular green card category does, it's under EB2, and I'm going to talk about that a little bit at the end, but it's under the EB2 category because just to maybe to back up a little bit in terms of the employment-based categories are broken down EB1 through EB5, right? So there are 5 of them. Now, this one is EB2, and EB2 is further broken down into 2 categories, one being national interest waiver and the other being just kind of generally a company sponsoring you for a green card. So now the great thing about EB2 national interest waiver is that it's based on, the particular rules with respect to this are based on a case. Now, the name of the case, it's called Danisar. And just one thing to keep in mind is we have separate webinars on national interest waiver because we can, for a lot of the topics we're going to talk about today, we could speak about them for an hour, and we do speak about them for an hour in different webinars. But there is a separate 2 different webinars on national interest waiver, one related to entrepreneurs and one related just generally to national interest waiver. So I'm just touching on it here, but you're encouraged to sign up for one of those webinars, or to go to our YouTube channel and look at one of the old webinars that we have on this topic. But the way that this particular category works is there are really 3 requirements, right? So the first requirement is going to look at what it is that the person says that they're coming to the United States to do. So this one is not so much focused on the individual, but more focused on what the individual says that they're going to do and whether or not that has substantial merit or of national importance, right? So now, one of the great things about entrepreneurs, if you're saying that what I'm coming to do, even if you said, okay, well, I'm coming to the US to make widgets, and widgets, were just, I don't know, like just widgets. They were just had no practical significance. They were just, something that you were going to make a lot of. But, this widget factory was going to have a bunch of employees and maybe some different locations, things like that. You could make even a national importance economic argument, right? That this particular business is going to hire US workers. But a lot of the time what we like to do is we like to combine the arguments, right? We like to combine and say that, well, one argument is the national importance related to job creation, but then also there's national importance with respect to whatever it is the individual is doing, right? So we try to look at what the individual is doing. And we do kind of pull together a very tight description of what the actual endeavor is, because of the 3 prongs, or the 3 requirements, I think that prong 1 is the easiest, in the sense that you can say anything, right? Like you can say in terms of whatever what the proposed endeavor is, that can be formulated in a way so that it is nationally important, right? Now, but then we move to prong 2, and that's where it becomes much more difficult, because now we're moving away from just what it is that the endeavor is, and we're moving now to the individual, right? And the individual that's applying for this. And now we're looking at, is that individual well positioned to not just do anything, but to do what you said in prong 1, right? So the grander you make prong one, right? Like you can make it extremely grand such that you get a nice check mark beside it. But the grander you make prong one, now you're having more difficulty in prong two, because it sounds like it's easy on, the entrepreneur is well positioned to advance the proposed endeavor. But it's not easy, because it's that endeavor that you talked about in prong one. And they don't just, they're not, they will look at things like your education, your work experience, et cetera, but they want a lot more than that. Like, so if you, it's actually a lot more than the E2 requires to show that your business is viable. They want to see that you have a track record of doing this before. They want to see maybe that you have investment, like other people that are investing or showing interest. If you're running an E2 business already, then you want to actually show them, like, Willis, if you're saying that employment is what's happening here, you want to show them that you actually have employees already, and that you actually have lots of contracts and things like that. And those are the things that are going to persuade them for prong two, right? So, but definitely, we've had great success with this, and clients on E2, and because that's the beauty of being on E2 is usually when you're on E2, you're not at ground zero, right? Like you have some track record, you have some, like if you're making an argument that you're going to create employment and you've had an E2 for 5 years and you haven't created any employment, then maybe national interest waiver isn't the one for you, unless there's some other endeavor that, national importance that you're talking about. But generally speaking, there's often something we can point to. And then the last prong is the government should, like, because what's happened in EB2, there's a labor certification process that says that, you basically, it's a process to where companies have to prove that they can't hire a qualified U.S. worker. And so the whole reason this is called national interest waiver, the idea is that the endeavor is in the national interest such that they should waive that labor certification, right? So the prong three is really looking at arguments as to why it is on balance, why it is that they should waive. And what we tend to do here is we kind of throw the kitchen sink at them here. Like a lot of what we talk about in prong one, a lot of what we talk about in prong two, but then the third thing we kind of throw in here, what's four things, right? Then the third thing we throw in here is any other spectacular things about the I was going to say alien, because that's the technical term in the regulations, but the applicant, any other if they've published things, if they've done other things, because we're basically saying, hey, look, at this person is pretty spectacular, so that's another reason to waive the labor certification. So we'll use some of the criteria in the exceptional ability or extraordinary ability, either one of them. But then the other biggest thing that we use here for entrepreneurs is for prong three, we kind of say, well, to tell you the truth, prong three isn't really relevant here, because and an individual that is on an E2 can't sponsor themselves for a green card, right? So that's what prong three is all about. Why should we waive the labor certification for this individual? And we're kind of saying, well, it doesn't really matter. And that's supported by the case as well, right? So it's supported by the case in the appeals cases, but we often, we would never just leave it there. Like we like to add more rather than less. So we would never just leave it there. We would use that argument. However, we would also point to, like, if in prong one, we have a bunch of expert opinion letters that say that this is the greatest thing since sliced bread, and it's going to revolutionize the U.S. economy, and all these different things. We're going to use that in number three, right? To say that, well, you should waive it because, and then the other thing with entrepreneurs is that prong three kind of falls on its face a little bit, because if the whole idea if prong three is saying, well, why the labor certification process is there to protect U.S. jobs, but if in prong one we're saying that job creation is what it is that we're doing, right, then prong three becomes a lot less relevant, right? Because it's supposed to be there to protect U.S. jobs, but the whole national interest, or at least one of the national interest aspects, is you're creating U.S. jobs, right? So I think it's another argument that we would make, and GA is particularly talented at making these arguments in national interest waiver cases, because she's worked on many of them. But they are, I describe them as they're probably the toss up between E2 and national interest waiver. I'd say they're my favorite types of petitions to work on. And so the final thing with national interest waiver, and I just think it's important to mention because we get so many calls for people thinking that they're eligible when they're unfortunately not, is that there is a threshold requirement for national interest waiver, EB2. So it's not even just national interest waiver, but EB2, whether it's company sponsoring your green card or EB2 national interest waiver. And that is that you either have an advanced degree, which is a master's degree or higher, or equivalent, which means bachelor's degree plus 5 years of progressive work experience, or something called exceptional ability. And they list 7 or 8 criteria, and you have to meet at least 3 of them. Now, what we get is a lot of people, they look at the exceptional ability criteria, and this is not to be confused with the extraordinary ability criteria, which are under EB1, but they look at the exceptional ability and they say, hey, yeah, I could meet 3 of those. And then they think they're eligible for NIW. But NIW is, before you even look at NIW, the hard part, the 3 criteria that I started with, you have to meet one, and it's either or, right? So you either have to advanced degree or bachelor's plus 5 or exceptional ability before you move to, like, what is it, Monopoly, where it says don't pass go, or before you pass go, pay 200. It's so long. I haven't played that game for so long. But but before you can pass go, before you can even start looking at the 3 prongs of DANISAR, you're required to actually meet the threshold requirement.
Right. And I do want to recommend our audience here to check out our dedicated webinars on the NIW itself, if you want to get more detail on that. Now, before we move on to the other categories, just one other question. Can someone self-petition for an EB2 NIW?
Yes, great question. And yes, the answer is yes. That's the other great thing about NIW, is that you don't need an employer. You don't need you can make the decision if you're on an E2, you can make the decision of who it is that is sponsoring you, petitioning for you. That can be yourself, or it could be your E2 company. It could even be, someone else. But that's the other great thing about this, the EB2 national interest waiver category, is that it is a self-petitioning category.
Right. Okay, so now let's shift gears a little and maybe talk a little bit about the $1 million green card, right? And I believe that is the EB5 investor green card. So could you talk a little bit about how one might move from an E2 to an EB5 green card?
Yes, exactly. And this was the one that I was kind of like a toss up between which one's the most popular, but I find that we have done some E2 to EB5 direct investment green cards, but the national interest waiver is more popular and even becoming like it's just more practical, more popular for many reasons. So let's talk about someone's in the US on an E2 and they decide that they want to move to an EB5. So let's talk about a case that we recently did. And this is a case where an individual has a farm, and they did an E2 for the farm many years ago. So they didn't use us for the E2 because the firm didn't exist at the time. I think they did the E2 over 20 years ago. And they had the E2, and then they came to us to assist them with applying for EB5 direct investment green card. So the EB5 is, it has similarities to an E2, but there are many differences. So the first and foremost is the EB5 green card requires that you have to invest a lot more. So it's either $800,000 or $1,050,000, and the difference is going to be determined by where the business is. So if the business is in what's called a targeted employment area, and that's an area that is designated by the government as 1.5 times the unemployment rate is 1.5 times the national average, then it's going to be 800,000, because the idea is you're creating jobs in an area that has higher employment, or it's going to be 1,050,000 if you are in any other area. So so first and foremost, you have to invest that money. Now, one of the things to consider is that some of the things that can be included in an E2 investment can't be included for EB5. So legal fees, for example, can't be included. Other administrative fees can't be included. So sometimes if you're using an E2 company, you do have to go through and kind of yank out some of the different expenses and say that these particular ones don't count. One good thing, though, is that the money has to be invested in what's called a new commercial enterprise, but that's any enterprise that was started after 1990, right? So, so in this case, where we had the farm that was started, over 20 years ago, that person at the time, the amounts were a bit different. It was only 500,000 they had to invest, but they had invested, $100,000 over a period of 10 years in the farm of their own money, and they were able to use all of that money for the E2 investment. So it doesn't have to be so a few things with that. A, it doesn't have to be invested at the same time, and B, it can be an existing business that has existed for a while, and the person can continue to invest in that particular business, and that can all be included. And this is an EB5 that was approved. It was approved about 6 months ago. And but the other thing to keep in mind is that although the investment can be made over time, the investment it has to be investment, like your personal investment. So it can't be retained earnings. So let's say that the company, for example, was very profitable and made, let's say it made $2 million in year one. And then year two, you said, well, I have, $2 million sitting around. So I'm going to now invest in, I want to apply for an EB5, and I've $2 million, and I'm going to spend $2 million in the following year, and I'm going to invest in EB5. That doesn't work, because that $2 million isn't your money, it's the company's money. It's retained earnings. So you would have to actually get $2 million from, or whatever the amount is, 800,000 or 150, 1,050,000 from some, your personal savings or personal money, and then invest in the company. EB5 is very strict with respect to where the money comes from you personally. With E2, you can invest through entities, you can do all sorts of things, but they're very strict with respect to that. Both E2 and EB5 allow you to take a loan or a gift. That's no problem. And both have the same rules with respect to secured loans. You can have an unsecured loan. You can have a secured loan against your personal property. You just can't have a secured loan where the business assets are actually your security. So that's the only difference. The other big thing with moving from E2 to EB5, if you are using your existing E2 company, then you have to show the source of funds. So where the initial, let's say you invested 100,000 or 200,000 in your initial E2 company, you have to show where that money came from. Now, even if you did a USCIS filing where they're very strict with E2 and where the money came from, like in the strictest version of an E2 filing and where the money came from, you'd have to multiply that by 100 if you were looking at EB5 in terms of how strict they are with source of funds. Like it really is incredible. How strict they are. And in fact, when people are applying for, it's the only reason petitions are denied often. Like it's one of the only reasons petitions are denied is source of funds. And they've taken it to really the nth degree. And so it really is they are the most significant parts of petitions, because some of the other pieces are did you invest $800,000? Well, show the money that you invested it. Some of the other pieces are a little easier to prove. Now, when we move to jobs, just like the investment amount under E2, you don't have a specific amount, but under EB5 you do. The same thing with jobs. With EB5, you're required to create 10 full-time jobs, and that's full-time jobs. It's not part-time jobs, it's full-time jobs, and they have to be full-time jobs for green card holders or US citizens. And E2, for example, the jobs can be really for anybody, but not so. And so there's a big thing with respect to I-9 compliance when you're actually going through the EB5 process, because when you are trying to prove that you created the jobs, you have to prove that they're actually people who are qualified to work. Now, the other thing to kind of keep in mind is that these jobs don't have to be created for 2 years after the I-526 petition. And when I'm just throwing that out there now, I-526 petition, that's remember I said there's always going to be an objective petition, and then you decide whether you do consular processing or adjustment of status. The I-526 petition is the objective petition for EB5. And I just want to throw something in because I'll forget if I don't. But for the EB2 that we just talked about, the objective petition is the I-140. That's the I-140. But so the objective petition for this one is the I-526 petition, and you don't have to actually create the jobs until 2 years after the I-526 petition has been approved, and the current processing time for I-526 petitions is 4 years. So you have lots of time to create the job. So they'll approve an EB5 based on a business plan, right? Based on a business plan, right? So it's not like, in terms of all of the pieces are really objective. That's why they generally can be easy petitions to get approved. However, the source of funds creates the issue, because we believe that all of our clients, that they got the money from a legitimate source, but sometimes it's not that simple, right? So we have one case where we have a horrible RFE from source of funds that started way back in 1965 or something like that, and USCIS, they just seem relentless with respect to not accepting that. Well, sorry, I don't have bank statements for 1965. I have a bunch of other stuff, but I don't have bank statements for 1965. So but they can just be really, really unforgiving when people can't get information, even in situations where you'd reasonably think that they should expect less, right, information. But unfortunately, they just don't care. One of the things that is important to note with EB5 filings as well is that there was a recent change in March of this year, and what the change was is that they allowed I-485 filings concurrently with your I-526 petition, which was a huge deal, because these petitions are taking 4 or 5 years to be approved. So someone could, enter the United States, file an I-526 petition, and then be in the United States for 4 to 5 years, with work authorization and travel authorization, just from filing the I-485 petition until their I-526 petition has been adjudicated. So it's really opened up an incredible opportunity for people to have status in the United States, because before that, in order to file an I-485 petition, you had to have an approved I-526 petition. So that, obviously made it so that there was no real benefit afforded to an I-526 until it was actually approved. So, but those are definitely some interesting things about EB5. And again, just like NIW, the EB5 is an area where we have separate webinars, so you can definitely look at that, on our YouTube channel.
Right. I think we had before we move on to the last category of the green card, I think we had a quick question on the Q&A box. From one of our audience. So what is the time period between the initial investment in the E-2 that somebody made initially, and the time allowed to complete an additional fund of money to do a direct EB5 investment? And I think you already sort of touched on it.
Exactly. Yeah, there's no time. No time.
Yeah, no limit,
So,
right? Yeah,
exactly.
definitely.
Yeah, you can just, all you're doing throughout the process is really keeping track of everything, and then so there are other things you have to look out for, but I think I think those are a bit more complicated, so they'd be more in the EB5 investment, but there are other things you have to look out for, but it is a kind of an exercise where we're accounting for, like, sometimes it's easy, like if someone has invested like $2 million, then we don't have to worry. But if someone's invested exactly $800,000, then we have to worry about how much has the person been paid. Did they take any bonus? There's a lot more we have to worry about. Like, did they include legal fee? There's a lot more we have to worry about to make sure that we can conclude that the full 800,000 was invested.
Right. And another question from the audience: could you pay dividend from the company and then use those funds for the investment, or use a salary from the company to invest?
Yeah, so it's a great question. So the answer is yes, but it's very complicated, because you'd have to pay it to yourself, pay taxes on it, and then reinvest it in the company. And you definitely have to have a very, very clear audit trail that it went into a bank account, then went into your personal bank account, then went back into the company. So it becomes much more complicated, but it is possible to do that. Yeah.
Right. Okay, so why don't we move on to the last category of green card option? So if an E-2 client has a special ability, is there a way for this person to move to a green card?
Yeah, so this one it is possible. There's an EB1A category. It's called extraordinary ability. And what I'd say is that I'd refer people. We do have another webinar on this particular topic, and what it is, there are 8 criteria that are listed. So, for example, does someone have a lead role in a critical organization, or lead or critical role in a distinguished organization, or have you judged the work of others? You have to you have to at least meet 3 of those. To be honest, we don't see as many people move from E2 to the EB1A category, because if they were doing the EB1A category, they maybe would have been here on an O1 before. So we don't see as many,
Right.
but we do, it is possible. We do EB1As for entrepreneurs. So it is possible. But what I do is I'd encourage everyone to go to the EB1A webinar, just to kind of look at those criteria and see if, and a lot of the time what we do as well is whenever we do an assessment of NIW, we often at the same time will do an assessment of EB1A, because as I mentioned with the 3rd prong of DANISAR, we're often looking for some of the EB1A criteria to throw in there to say that, hey, this is another reason that we should waive the labor certification.
Right. Moving on to the other category then, is it ever possible for an E2 company to sponsor the owner for a green card or the family member?
Is it ever possible? Yeah, well, I think that generally speaking, no. So when you have an E2 visa holder and the individual is owns over 50% of the company, then then they can't sponsor themselves, and they can't sponsor their family members. Now, what ends up happening often though is another kind of big way that we often see people move from move to green cards is that individuals, one of their family members gets a job, and that particular job is they're eligible for a particular green card, and then they get that green card, and then the E2 visa holder can join in that particular process as well.
Right. And would there be any other green card options for E2 visa holders, just so that we cover all of our bases other than what we've already discussed?
Yeah, so I think that there are a few other that they're not that common, but I think that sometimes people we maybe 4 or 5 times we've had people that are on E2s win the diversity lottery.
All right.
So that's definitely. And then there are sometimes people that they're on an E2 and they have some humanitarian based ability to get a green card, like maybe they've witnessed a crime or something like that,
I see.
and humanitarian based. But it's not, those are definitely not that common. So.
Right. So we may not be able to go all of the questions as we're running out of time a little bit, but just to get to what we can, what will be the disadvantages, right, from coming off of the E2 visa status and for applying for a green card instead?
Yeah, I think that the disadvantage really is, like, there could be a tax disadvantage. So when you have the E2, then you might have the ability to, let's say that you didn't plan on staying in the United States, such that you had became a resident for tax purposes. Then it could be that you could work that so that there was some tax benefit. Whereas if you're a green card holder, you're automatically a resident for tax purposes, just based on you, even if you don't spend a day in the United States. So there's maybe some tax planning, tax planning opportunities. Also with the green card, if you've been on a green card for many years, and I can't remember the exact, again, it's a tax issue, but if you left after 10 years, when there isn't an exit tax, which could be quite substantial, which you wouldn't experience with an E2 visa. So those are, definitely it's good to look at those tax issues, because that's we do sometimes have people who select an E2 just based on the fact that they don't want to just based on the fact that they don't want to have to be subject to U.S. taxes just by default.
Right. And so I guess the last question is maybe what we can end on. And if there were any questions, please feel free to schedule a consultations with us, and we'll be able to look at your situation more closely. What would be some of the risks of green card application on a subsequent E-2 application, for example? So a related question is an E-2 visa a dual intent visa? If you have a pending green card petition, for example, via a relative, how would this affect E-2 application?
Yeah, great question as well. I think that it goes back to just making sure that everything's being timed. So whenever we are moving someone from an E-2 to a green card, we try to structure it so that during the process that they're not going to have to renew their E-2. Right, because if you have a pending green card application, then it might make it harder to renew your E-2, depending on the nature of the applications. So for example, before, if you had a pending I-526 petition, renewing the green card, renewing the E-2 wasn't going to be a problem because they didn't allow you to adjust status until the petition was approved. But now that they do, I think it would be difficult to renew an E-2 application if they saw the I-526 pending, because they'd know you had the ability to adjust status if you came into the US. So I think that it's always looking at timing and trying to time everything so that they wouldn't have to do, the person wouldn't have to do the renewal, but also that as the person is going through the process, even if they did have a denial on the green card petition, they still had more time on the E-2, so that then when they did go to renew the E-2, they wouldn't, they may have less of an issue. And then sometimes what we will do as well is, if a case is not as strong as we would like it to be, like, so let's say someone wants to file a national interest waiver case, we may advise the client to not file the I-485 petition, even though they're permitted to, right? We might advise them not to file the I-485 petition, because the I-485 petition is a stronger signaling of immigrant intent. Because the whole thing with immigrant intent is that there's no prohibition against an individual planning to get a green card. What the prohibition is that an individual having the intent to enter the United States and adjust status. That's what the prohibition is, which is different, very different from the person having the intent to get the green card. So when I say that, mean that if an individual was entering the United States and planned to consular process, the person would not be prohibited from entering the United States and should have no issue at a border, right? So the issue always is the person coming to the United States intending to adjust status. And in order to do that, you need a dual intent visa. And sometimes that's why you can run into problems if you don't have one. So you want to do everything you can to plan against that. So.
Right, definitely. Okay, so I think that is the end of our session today. I hope this session was helpful for many of the people in the audience. We are happy to schedule any consultation with any one of you if you would like to discuss your particular facts of the case further. So my apologies if we haven't got to every single question. And Ian, thank you so much for your time. This has been very, very informative.
Great. Thank you very much. Okay. Thank you.
Thank you, everybody.